Good morning, everyone, and welcome to the 33rd meeting of the Net Zero Energy and Transport Committee for 2025. I welcome to the meeting Sarah Boyack, who will be attending as the substitute member for Monica Lennon for consideration of the Ecocide Bill. Under Rule 19.13a, our standing orders, Monica Lennon is not entitled to exercise the rights of a committee member in relation to the bill because she is the member in charge of the bill. This means she cannot participate as a committee member for any of today's items of business which all relate to the bill. However, as we can see, Monica is present for the evidence session, and like all other members of the Scottish Parliament, when they attend this committee, she'll be entitled to get some questions at the end. I'd also like to make everyone aware that sometime after 10:50, when I consider appropriate moment, I will pause the meeting to observe the Armistice Day 2-minute silence and allow members to attend in the garden lobby. And I've said to the witnesses, if they are here at that time, and I will obviously escort you down there if you'd like to attend that event as well. So our first item of business this morning is a decision on taking item 3 in private. This is consideration of the evidence heard earlier in the meeting of the Ecocide Bill, including consideration of our approach to further scrutiny at stage 1. Do we agree to take item 3 in private? We are agreed. Our second item of business this morning is an evidence session on the Ecocide Scotland Bill. We're gathering evidence on the general principles of the bill before we report to the Parliament at stage 1. The Parliament has not yet set a stage 1 deadline. Today we'll be taking evidence over 2 panels, and these will be our 4th and 5th evidence sessions on the bill. And I'd like to welcome our first panel this morning. First of all, there's Dr. Claire Frances Moran, Lecturer and Coordinator for Aberdeen Centre for Constitutional and Public International Law and the University of Aberdeen, Murdo MacLeod, KC, Rachel Weir, the Head of Policy and Engagement for the Crown Office and Procurator Fiscal, and Ian Batho, the Head of Wildlife and Environmental Crime, also from the COPS, Crown Office Procurator Fiscal Department. Thank you for attending. I'm going to get the first question, which is the gentle warmer into the bank to get you into the swing of answering questions. So the first question is, do you agree with how ecocide is defined in the bill, or do you have suggestions of how it could be strengthened? And is the bill targeting the appropriate level and type of environmental harm, which allows for any future challenges for interpreting the definitions? Are those dealt with? So I'm going to come to you first, Claire, if that's all right, and see what your views on that are. Claire.
Thank you very much, and thank you for inviting me to speak today. I think that it's a good thing to criminalise ecocide. I think there are a few issues with the definition as it stands. The first one is that the definition of harm is taken directly from Section 17, subsection 2 of the Regulatory Reform Act 2014, and it is very, very broad. It doesn't necessarily pertain to the sort of harm that ecocide might relate to. And as an example of that, I would give that 17.2 includes offences to human health, human senses rather, so offences to human senses, which are not necessarily things that we might consider to be ecocide. The second thing is that I think serious adverse effects is maybe refining a little bit of definition. You can see where there's a synergy there between the connection, more than a synergy between the definition of ecocide put forward and the section 40, subsection 2 of the Regulatory Reform Act. And I think maybe that needs further definition to understand what we mean by ecocide. I'll hand over to the other members of the panel. I don't want to dominate.
Okay, they're all waiting to see who's going next, and it's Ian, and then we'll go to Rachel, and then we'll go to Murdo to put the others out of their pain of waiting. Ian.
I think there's arguably some ambiguity in relation to some of the terminology. I think the term limited geographic area in the definition of widespread, there's maybe a bit lack of clarity there. And I would agree that the term serious adverse effects, that term is used in Section 40 of the Regulatory Reform Act, but there is no definition in either piece of legislation of what serious means when that threshold has been crossed. I think sort of more importantly from the sort of prosecutorial point of view is not what we think of those definitions, though. It's in particular what do SEPA and particular SEPA scientists think of those definitions. And sort of thinking of the end game from our point of view, what we're ultimately doing here is we are asking a jury to make a final decision on guilt. And the way we would do that as prosecutors is we would present a case to the jury in such a way as to help them come to that conclusion. And the way in this type of case that we would help lead a jury to that conclusion is by leading the evidence of probably expert witnesses. And in these kind of cases, the expert witnesses are most likely to be SEPA scientists. So what we are ideally going to be looking for at a trial when we put a SEPA scientist in the witness box is for them, in an ideal world, it's never quite as easy as that, for them to go, the adverse effects of this incident were serious, or to say the adverse effects were widespread, and then to provide sort of evidential backing behind that statement. The reason why I think it's important to know SEPA scientists' position on these definitions is so that they can come to those conclusions to help us lead a jury to the verdict we ultimately want them to reach. So I think key questions we would have are, is the current way the definitions are formulated in such a way that SEPA scientists would be willing or able to stand up in court under oath and say that those standards have been met? Do scientists understand the terms sufficiently to be able to do that? Will the science ever be sufficient for them to adopt such a sort of clear position? And then there's a sort of slightly broader issue of, is there a clear enough understanding and consensus among the scientific community as to what these various definitions practically mean? I think without clear definitions or guidelines to create an objectively measurable standard in relation to these definitions, proving these thresholds will come down to the subjective view of expert witnesses. So we can foresee an issue where if there was a vast array of subjective views and interpretations of these definitions amongst the scientific community, that makes life slightly difficult in terms of we would lead a scientist who would potentially say these standards have been met, but then if the defence produce their own defence expert witness who has their own different subjective view and thinks the standards haven't been met, then I think a potential outcome of that is that a jury is going to be left with a reasonable doubt. So I think without that clarity from the scientific community, and in particular SEPA scientists, I think the prosecution perspective could be quite challenging.
Well, it sounds like more questions than answers there, Ian. We'll see how we go with Rachel. Are you going to give us more answers than questions?
I feel I'm kind of setting myself up for failure here. I'm going to disappoint you. And I really, there's probably not very much that I can add, given such a thorough exposition of it by Ian. I mean, I think it's important to just reflect that defining any kind of criminality is always complex. There's always a difficulty around that, and there's always scope for interpretation in relation to it. And that doesn't take away from the policy intention behind the bill, which I think we could say we could support that, because it does raise awareness in relation to environmental offending. But it's important that the detail's right, because otherwise that good intention, if the definitions aren't quite as sharp as they need to be and don't match up, as Ian said, with scientific evidence, we would find ourselves in a difficult position as prosecutors in bringing life to that legislation. And so I would encourage the committee to consider taking evidence from those experts to inform your consideration of what the definition should be.
Okay, and I'm going to come to you, Murdo. Enough wiggle room to cause seeds of doubt to be sown?
Yes, I take a slightly different view to what Ian had to say about the divergent, perhaps, views of expert witnesses. That commonly occurs in the criminal courts when one is dealing with regulatory offences. One thinks of health and safety matters in particular. You'll have a phalanx of experts to both to describe, for example, whether a Legionella outbreak caused a death or what steps were taken to counteract that possibility. In general terms, I think this is a very well drafted bill. There are a few issues that I have with it, but I think it is well drafted. The reference back to the 2014 Act really has a list of the different environmental harms that can be caused. And I think that is probably adequate in the circumstances. The one caveat I have is and again, Ian has mentioned it there, is the distinction really between significant and severe when they are both defined as being serious adverse effects. It's not quite clear to me what the distinction is, and drilling down finally into that a little bit, we see that in section 40 brackets 9 of the 2014 Act, something is significant if it has serious effects, whether locally, nationally, or on a wider scale. So that could encompass the widespread definition that we see in the current bill. But subject to those comments, as I say, I think the definition of ecocide is appropriate, and indeed it's not actually mentioned as a specific crime in the EU directive, I note. They're just different examples given of what that could be.
Okay, so one of the issues, thank you for that, one of the issues that we've been examining and sort of questioning is the Regulatory Reform Act 2014 is quite clear. I'm trying to work out in my mind why we need this as well. So my question is to Rachel, do we need this as well, or is there sufficient coverage in the Regulatory Reform Act? And I'm going to ask each of you that, so you've got time to think about it. Sorry, Rachel, you're first, and then I'm going to Ian, Claire. No, Ian, Murdo, and then Claire, because she went first last time.
Happy to. We don't identify as an organisation any particular gaps in the current legal framework that exists that the bill would fill. So incidents that are currently considered that involve environmental harm can generally be addressed within the existing framework. So from our perspective, it's not entirely clear to the Crown Office and Procurator Fiscal Service what particular circumstances that are being envisaged that would be covered by the ecocide offences that couldn't already be addressed within the existing framework. Now, I know you're going to turn to Ian next, and I'm grateful for that, because I think he might be able to breathe a little bit more life into that than I can.
Okay, Ian.
I mean, the reality is we can only really go on reports we have received. In the 2.5 years I've been in position, the number of cases that we've received from SEPA relating sort of serious environmental offences, I think there's about 6, all of which we have considered there to be existing sufficient legislation to be able to prove offences in relation to those matters. So certainly practically, we have identified no gaps in the legislation in the cases we have received. Caveat to that, obviously, is we only receive cases that reporting agencies consider there are offences for. So there may be things behind the scenes that have never been reported to us, and we can't comment on that, and SEPA would be best placed to comment on that. But, I mean, certainly I can say that we work closely with, or I work closely with SEPA. I have meetings with them every 6 weeks to discuss live investigations, and it's in my time, it's never been flagged to me that there is an incident we're investigating and we can't find any legislation that covers it. That's not something that's been raised to me before, so that's sort of practically not something I've encountered. And I could give examples of the cases we have put into court and successfully prosecuted under a variety of different legislative provisions. I won't waste your time listing them, but there is a number of provisions that we have used, some of them repeatedly.
Murdo, new law, more opportunities, or sufficient where we're there?
Well, there would be more opportunities if they were ever prosecuted, but as we know, prosecutions are quite thin on the ground in this field. It seems to me it's clearly designed to cover some sort of catastrophic event, and I think that must be, I presume that's the reason that there's this new piece of anticipated legislation, but also, as it were, it does what it says on the tin, whereas there is a current offence on the statute book in the 2014 Act. It's kind of buried within a lot of other regulatory offences. I think the next one is something to do with the supply of polythene bags and the like, whereas this is a sort of not a symbolic act as such, but it would certainly spring to the public's mind, and indeed would be brought home in boardrooms around the country, I suspect. The fact that there are 2 separate crimes I should say I'm speaking today in an entirely personal capacity, but it doesn't bother me, because we know that this Parliament is either enacted or very close to enacting the dog theft bill, and of course in common law the theft of a dog is just another theft. So you can legislate what you want really, but I will leave the question of whether it's desired or merited or not to yourselves. It really is a matter for, and I'm sorry to pass the buck, we only implement the law, but it's for the members of Parliament to...
Before I leave you though, since 2014, could you give me one event where this would have been more appropriate than the legislation that we've got already?
I can't think of any disasters that have occurred actually in that period that would merit this. But as I say, who's to say there wouldn't be one next week or in a month or two's time? I just don't know. It's entirely for Parliament to decide whether it goes in the sort of general direction of travel of other countries and other organisations or not.
And no Parliament thinks carefully about enacting new legislation. Claire, do you want to say anything on this?
Yes, I think that I agree with what's been said already, in the sense that I think the ecocide bill and ecocide in general and international law is set out to capture events which are very, very serious. Doing sort of research on the sort of events that have happened in Scotland in the past few years. And there's nothing that I think that would meet that definition yet, but that's not to say that it wouldn't happen. The ways in which I would identify this goes further is that the widespread element goes beyond a limited geographic area. And I think that that is not something which is captured by Section 40 at present. And beyond that, I think that the current definition in ecocide would not permit any defence to be raised of a permit having been issued or an authorisation of any sort. So that removes that possibility. And in the scholarship, which is what I'm most familiar with, the example given there is of a situation in which, for example, a large sort of project which had a great deal of emissions associated with it, I'm not going to say anything in particular, but a large project with a great deal of emissions, if that was approved, then perhaps that might contribute towards ecocide, and it would be caught by this provision, but perhaps not by Section 40. That's my understanding.
Thank you, Claire. Mark, I think you've got a brief sup.
I was wondering to what extent case law helps us to make a distinction between significant environmental harm and severe environmental harm.
I'm personally not aware of case law in relation to it, so I think the definitions are... My primary awareness of that definition is in the Regulatory Reform Act, which, as it hasn't been prosecuted yet, hasn't been tested in the courts. I would be going and relying as a prosecutor on the definitions within the legislation, is what I'd be relying on. I'm not aware of any key cases that would aid that interpretation. There may be some, I'm not aware of it.
Okay. Okay.
We'll go to the Deputy Convener, Michael Matheson. Michael.
Good morning. We've had a bit of a rear-view look at potential instances that this proposed bill could actually be considered for, and no one's identified any particular instances since, I think, 2014. You went as far as saying, Mr MacLeod. I think what I'm interested in getting your view on having a look forward, and given your experience with the existing legal framework in this area, are there gaps in the existing legal framework that you think could present as a gap to your ability to prosecute in an instant where severe environmental harm has, or significant environmental harm has occurred? I wonder whether, Ian, if you would be able to comment on that, in particular, given your expertise in prosecuting in this area.
I think we have struggled to identify a scenario where the existing legislative framework wouldn't be sufficient. I think the one area, if we're talking about this 1 in 20 years significant incident, I think in terms of an offence to obtain a conviction, I think there is other offences already there, most notably Section 40. I think the one gap, if we're going to call it a gap, is provision for if Parliament is looking for a sentence of up to 20 years. The existing legislation, most of it is essentially capped at 5 years. So I think that is the gap, if you're wanting to find a gap where, if that massive incident occurred, where we would be limited. But in terms of actually offences that we could prosecute such an offence under, I think they already exist, as we've outlined.
Okay. Murdo, from your experience?
I agree with Ian, and as I said earlier, the only reason I mentioned 2014 is because that's when the last Act came into place. I can't even remember one, frankly, prior to that in my working memory, which would have necessitated this sort of section dealing with a one-off catastrophic event. And I would agree with regard to the sentence. But of course, if Parliament thought that the sentence was lagging behind in terms of what it should be, and to mark the gravity of it, that 5-year penalty could be amended and increased.
Mm-hmm. Okay, thanks. Can I pick up as well on the point that you mentioned around the overlap in law? So if this bill was to be introduced, I'm interested from a prosecutorial point of view. Obviously, it's not uncommon to have areas of criminal law that may cross over one another. Does that present any challenges for you as a prosecutor in deciding which route to follow in order to take forward a prosecution?
I think potentially yes. To explain the way we would do it is that, every case comes down to its own specific facts and circumstances, but you'd look at the facts and circumstances of the case and the evidence available, and step one is identifying which offences could we potentially prove. If you then have a number of offences which you could potentially prove and you need to choose one over the other, essentially it's a sort of wider public interest test, but some of the key things we're going to be looking at is which charge is most likely to result in a conviction. And then secondly, there is the element of sentence as well. Does the charge we're proving enable the sentence that we envisage being likely? I think it's important to stress that with a direct comparison between Section 40 and the new proposed ecocide offence, in every sense, Section 40 is the easier offence to prove. Looking at specifics and comparing the two, ecocide requires evidence of actual harm. Section 40 requires likelihood of causing harm or more. I think the really key one, from a prosecutor's point of view, that makes the biggest difference is that ecocide requires intention to cause harm or recklessness as to whether harm is caused, whereas Section 40 is strict liability. And I think the importance of strict liability cannot be overstated in terms of that is a significant evidential hurdle that doesn't need to be overcome from a prosecutor's point of view. And then in addition, ecocide has those additional tests of requiring serious adverse effects to be either widespread or long-term, which Section 40 doesn't. So essentially, by every comparison of the two, Section 40 is the easiest offence to prove. And from a prosecutor's point of view, if we are looking at the public interest is probably going to be which offence is most likely to result in a conviction. And looking at them, I think my position would be Section 40 is the one that fits that the best. The difficult situation that I could foresee occurring is this big situation happens that we're talking about. We are comparing the two offences. We go Section 40 is the easiest offence to prove, but it's going to cap the sentence of 5 years. Whereas the ecocide offence is going to be harder to prove, potentially with a lower prospect of conviction, but if we get the conviction, there's scope for a higher sentence. That is a difficult situation to be in as a prosecutor. It could be seen as it's almost like a gamble, a sort of double acquit situation, which isn't, I would suggest, not the most ideal scenario within which to be making important prosecutorial decisions. So I think that's my position in relation to that.
I think that's an interesting concept because if you have both of the offences as is drafted in the bill at the present moment, I suspect that if you are seeking to try and increase your chances of getting a prosecution, from what you're saying, you're more likely to pursue it under Section 40, even though it may have a capped sentence because it may be easier for you to get a prosecution under it. Is that in essence what your
exactly,
suggestion
yeah.
could happen?
And the solution that would avoid that difficult situation as a prosecutor is for Section 40 to also have that higher sentence. But then arguably, if you're choosing between the two and they both have the same sentence, I think the sway would be to Section 40 because it's the easier offence to prove.
Which could potentially one of the unintended consequences of having two areas of law that overlap one another.
Yes.
On this. Okay. My next question is in relation to the whether the bill you think is clear enough around the issue that it talks about as a course of conduct that is consequent about impact over a period of time. Do you think that, as well as a one-off incident, do you think the bill as it stands at the present time gives sufficient clarity on an instant or instance that occur over a period of time that could then be considered ecocide? Do you think the bill gives sufficient definition around that, or well, there's a need for further clarity in that area?
Is it myself?
We'll ask Rachel to give you a rest, Ian.
Prosecutors are used to working on the hop, it's fine. I think we're pretty clear that the definitions in relation to course of conduct are pretty clear within the provisions. Courses of conduct are not an uncommon feature of criminal prosecutions in Scotland, and increasingly so we see it in relation to domestic abuse and the Domestic Abuse Scotland Act, where there is the foundation of the offence is a course of conduct. So it's a concept that's not only familiar to prosecutors but familiar to Scottish courts. So, and I think from looking at it without delving into it in more detail, it's clear enough. And what I can offer to do to the committee is to follow up in writing afterwards, and it's our intention to do so, to take into account the thoughts of the committee and submit a written submission thereafter. Okay.
Murdo?
I'm sorry, Mr Matheson, I'm not sure where it says there's a requirement for it to be a course of conduct in the new bill. They commit an offence, Section 1, if the person causes severe environmental harm and the person intends to cause environmental harm or is reckless. That to me would suggest that it doesn't really matter if it's a one-off event or over a period of time. And in fact, in my experience, environmental crimes, maybe not quite as serious as this, but pollution that occurs isn't just a one-off. Perhaps it is offshore with a pipe that's burst, but for a lot of the time that may not be discovered, for example, for 2 or 3 weeks. So I'm not that fussed about course of conduct as opposed to a one-off incident.
Okay.
Okay. Douglas, I think you wanted to come in with a supplement.
Briefly to Ian, you mentioned whether you would go down the ecocide route or the Section 40 route for prosecution. If you went down the ecocide route, just for my knowledge, would you then be able to, if that wasn't successful, would you then be able to go down the Section 40 route? Would that be it?
We'd have to tire colours to the mast and decide which offence we're prosecuting under.
Thank you. Thanks, Commissioner.
Interesting. Okay, thank you. Mark, you've got the next questions.
Yeah, I just wanted to come back to that issue about the threshold for liability that you were discussing there, Ian. I mean, it is the case that the bill requires intent or recklessness. Do you think that the bill could also extend to negligence or provide for strict liability for organisations, so perhaps moving more into that Section 40 territory rather than just staying purely on that intent or recklessness, which, as you said, is a much higher bar to be able to prove, and creates then a choice about which provisions you go for?
It could. I think it then becomes even more similar to Section 40, and I would struggle to see. You've still got the slightly. There's a number of elements where Section 40, the ecocide offence, is a harder offence to prove. That would overcome one of those additional challenges that isn't present in Section 40, but I think there's a few others. But I mean, it is an approach Parliament can take, and it has been done in Section 40, and that's legislation that's been passed. So
Right.
I don't know if
I mean,
that's
it would
helpful.
depend if it was severe or significant, I guess, and then the higher sentencing would be available.
Yes, yeah. I am perhaps struggling to really identify maybe Parliament has a clear vision of 2 tiers of harm and seeing ecocide fitting one and Section 40 fitting another. For me, I look at Section 40 and see that covers the most severe eventuality, personally. I think we could prosecute under Section 40 for the big event we're envisaging, so I maybe don't see it as that sort of 2 tiers of harm.
Okay. Can I get other views then on the threshold for liability that exists within the bill? We go to Murdo and Claire and then Rachel.
The one equivalent would be one statute I mentioned earlier. It's the Health and Safety at Work Scotland Act, which is almost like qualified strict liability, so that there's a defence in there of reasonable practicability. The onus is thrust back onto the company to discharge that. That is not obviously what is in the bill, and I think that is that's fair enough, because the extension of the Health and Safety at Work Act is to corporate homicide. Again, we've not had a prosecution since 2007, since its inception, but that is a higher standard, and that requires the prosecution to be on the front foot because it is such a serious offence. And I think for this, the prosecutors too should be on the front foot and should be required to prove it. And I presume that is the intention of this bill. That's why there's a distinction between the regulatory framework, as it were, under the 2014 Act and this specific crime. I think it would be too big a step to make it a strict liability.
Yep. Okay. Claire, do you want to come in?
I would agree with that in the sense that I wonder if the current drafting of the ecocide, the crime of ecocide, has perhaps been inspired too greatly by the 2014 Act and by other elements of the legislation. Something I meant to mention earlier is that we do have a definition of serious adverse effects in the Environmental Liability Scotland regulations in 2009. It's not particularly clear, but there is one there, so there are definitions of these things. I think that ecocide, based on what other countries are doing, based on the movement regionally and internationally, it's supposed to be very serious, so I don't think strict liability would be appropriate. It has to be intentional. And consequently, you would need, I think, one might need to divorce it slightly from the 2014 definitions and aim more towards what we're looking at here. The other thing that other documents have done in the area, sort of thinking of the definition in Belgium, which has come into force very recently, but also the Council of Europe Convention on essentially criminalising violations of environmental law, and the EU directive as well. Both the EU directive and the Council of Europe Convention have both set out examples and then said the worst examples of these would qualify as very serious crimes. And in the preamble to both, they kind of say this might be things allied to ecocide. So in that way, they have given examples, and it's much easier, I think, to conceive of as lawmakers, as practitioners, as even academics, of what ecocide might mean. If we're deriving it from an existing criminal law provision, regulatory provision, I think that's maybe where the difficulty lies. Ecocide is supposed to be the very worst that one can do on a cumulative basis, on a one-off event basis. It's the worst of the worst, essentially.
Okay, thank you. Rachel?
Just to go to that question of strict liability or not, as the case may be, ultimately, we can sit here and advise that it makes it more difficult to prove if it's not strict liability, but it's a matter for Parliament to decide whether, and I think Claire's highlighted some of the reasons why Parliament might want to take a different approach in relation to this, but that's a question of policy and not for practitioners such as myself. I think the point that Ian made is the one that really I would endorse and adhere to and recommend to you as a committee, and that we can't envisage any set of circumstances. Obviously, there's a degree of this which we're all future casting and trying to anticipate the cataclysmic event that has not yet happened and may happen in the future. But we can't envisage any set of circumstances where we couldn't use the existing framework, subject to the caveat that Ian mentioned around the difference in sentencing. Again, sentencing is also a matter for the court.
Okay, thank you. Can I also ask you about how criminal liability can be established, particularly within, large corporate entities, multinational organisations?
On that one, I'm going to actually hand you over to Ian, simply because he's got greater expertise in relation to the prosecution of corporations. I think as a headline, I would say it's not uncommon for us to prosecute companies, and Ian has a very apposite example that he might share with you. It's something which arises day and daily for prosecutors. And so there's nothing specific that arises in relation to a corporation in terms of difficulty, but I'll pass over to Ian to give you some practical examples.
I'm particularly interested in relation to that threshold of intent and recklessness.
It's a question of the looking at the controlling mind of the company and establishing what the company was aware of and what the company knew. And although a company isn't a person, it is a legal person. And so you can establish through the thorough investigation of the corporate actions what was within their knowledge, contemplation, and the extent to which they've acted intentionally or recklessly. So again, rather than thinking about it in terms of a company and that being more complex, in fact, it's just a different type of person.
Yeah, I mean, the slightly wishy-washy answer is how we prove that depends on the very specific evidence we get in every individual case. I think it's so complicated that trying to describe how we prove it in the abstract is almost impossible. But so the issue of recklessness in relation to companies, recklessness can prove challenging when it involves companies, and particularly incidents that involve multiple companies with multiple levels of management. Really, the step one in proving who was reckless is proving whose duty, whose responsibility was it to carry out the necessary due diligence. And that is often a point of contention where you may have multiple companies all pointing at each other and going, that was your job. And I think the challenge from a prosecutorial point of view is that the evidence that can establish the truth of that is usually held by the very individuals and companies that are potentially being investigated and looked at from a criminal perspective. That can be challenging. A real benefit that SEPA has over Police Scotland is that SEPA have powers to compel individuals to answer questions, compel individuals to hand over documents. So I think SEPA are better placed than others sometimes to actually wade into these companies and obtain the evidence they need from employees or obtain the documents. And so it may be that evidence you get in terms of recklessness comes from, it's usually internal company employees or internal company documents, minutes of meetings. That's the kind of thing we would practically be relying on to establish recklessness on the part of the company.
Okay, I'm going to move on.
Yeah, I think the Deputy Convener wants to come in with a follow-up.
Yeah, just a follow-up on that with Ian. If there was an event where an employee in a company acted negligently and out with the company's procedures and resulted in an act which caused serious or significant environmental harm, and you were looking at a prosecution, in that instance, who would be prosecuted? Would it be the company, or would it be the individual who acted out with the company's procedures that resulted in the harm being caused?
Again, I tread carefully talking the abstract, but if a company had exercised every level of due diligence that it should have done, there was clear guidelines to employee, clear instructions to an employee, clear oversight and management of the employee, the company had done everything they could and should have done, and yet an employee went rogue and caused the harm, my expectation is we'd be focusing on the individual, the employee, prosecuting them as an individual for causing the environmental harm. I would expect, but there is so many permutations and nuances that it's speaking about in the abstract I'm wary of, but hopefully that gives an indication of where my head would be at.
Yeah, no, I think it's helpful because there has been some suggestion of the bill being amended so that anybody being prosecuted under the bill could only be those who are senior managers within an organisation, that and I've tried to understand the concept of if you have an employee who carries out an act which was out with the company's procedures, etc., and they shouldn't have done that, that's caused this significant environmental harm, how do you then prosecute a senior manager within an organisation or a director of an organisation who knew nothing about it, was not involved in it, the person had acted out with the company's procedures, but you then pursue a prosecution against them that could result in them being in prison for up to 20 years? I don't understand how you would take that forward as a prosecutor, or how our courts would look upon it.
Do you mean against a manager who had done everything they should have done? Is that who you're meaning?
Yeah, and the organisation, the company, the corporate organisation have done everything that they should have done. All the procedures were there, but there is someone, an employee, has acted in a way that has, out with the company's procedures, that resulted in a significant environmental harm. But some have suggested that the bill should be amended in a way that, irrespective of that, it should be the directors of the company who are prosecuted. It's not in the bill. It's been suggested the bill should be amended in order to do that.
Murdo is buzzing to come in because he wants to defend somebody, but there's...
Yeah, I think both of these eventualities, I think, are covered by sections 3 and 4 of the bill. So you've got the corporate responsibility in the vicarious liability section, and it is a defence that will maybe come on to defences, which I've got a slight problem with, but there are defences there. So in your scenario, the company could say, well, we didn't know that the employee opened the valve or whatever, and that would be a defence to that. And looking at it the other way round, you can pin responsibility on management, and we have the table that is contained in section 3. But again, you have to pin it on the company, and then you're looking at a senior manager to see, well, did they know about it, and did they do nothing about it? And I've got one comment on that, if I may, Chair, which is in section 3, where we have the table with the relevant organisations and the relevant individuals. I think in terms of the Corporate Homicide Act, which I go back to, there is reference there to senior management as opposed to management. And I'm just concerned that in terms of public authorities, which I defend quite often, it isn't senior enough because, as you will be aware, they are quite flat organisations. You can get hundreds of middle management, and I'm concerned that the bill doesn't address the fact that for a body or organisation it should be a senior manager. At the moment it only says is concerned in the management or control of the affairs. I think there should be, if it's to come in, I think it should be. So
I think my issue is that there has been some evidence that we've received suggesting that there should be an amendment to the bill so that it can only be applied to senior management.
Right. Yes.
And what I've been struggling to understand is that if the bill was framed in such a way,
yes,
but the act was carried out by a member of staff that senior management knew nothing about,
yes,
what they were doing, and that they were operating out with the company's procedures,
yes,
who would you then? How do you then prosecute?
Well, it would be up to the Crown to prosecute that, because they would have to fix the knowledge onto the company. And it's covered, as I say, in Section 4, vicarious liability. It's a defence for the company to show that they didn't know, or the senior, what was happening at the time.
And if that defence is removed,
if that defence is removed, then it almost becomes like a strict liability. I think that would be a little bit. My own view is that would be a little bit unfair.
I do think you have the word causes in there, and I think the word causes is significant because there's an argument that if a company did not instruct this individual member of staff to go and do that, it was an entire folly of their own. Can we prove that the company caused that harm? And I think that is maybe the first level of protection against the company in that scenario where, quite frankly, they had nothing to do with it. It was an employee going rogue. Causes, I think, your first level of test there that might assist the company. And then if you're delving down into consent and connivance of directors, you have that later sort of clarifications later in the bill as well.
Okay, thanks.
The willful blindness aspect has gone. The negligence, which was, I think, in the 2014 Act, the consent, connivance or negligence, that the negligence aspect has gone. So it does make it a little bit tougher now for the prosecution.
Yeah, I think it's not the provisions that are in the bill, it's the suggestion that those provisions should be removed in a way that would result in that only individuals who could be prosecuted are senior managers.
That was in the first evidence session. I think we heard that there was wanted to be an absolute protection against individual workers, and it was only companies that would hold responsibility. I think we're getting the impression that that's not a sensible way forward, from the panel today anyway. Okay, Douglas, I think yours are the next. Sorry, have you finished, Mark?
Yeah, finished it.
Douglas, I think yours are the next question.
I'm just going to stay on vicarious liability first. I'm just trying to understand, you know, if a company contracts work to another company, I'm trying to think how far it would flow up to the original company. Do you have any thoughts on that, Murdo? Or?
Not really. I noticed that in terms of the original Act, as it were, the 2014 Act, it was a defence in terms of Section 42. In other words, no offence was committed by a person who permitted another person to act or not, as mentioned in the subsection, if the permission was given by or under an enactment conferring power to the person to authorise the act. So that is now gone. So just in terms of how far up it goes, I'm not sure. But and I'm not a planning lawyer, but if one imagines that consent has been given and there's a very difficult environmental regime to get over, where does the buck stop? Because the company will maybe subcontract something to someone. This is the valve that's turned by mistake. Yeah. That company may, I suppose, have caused that to happen in instructing them. But if they are legitimately acting under some sort of environmental permit, then I do wonder why that defence is not now open under the new legislation. I'm sorry if that doesn't answer your...
No, it does. Ian, have you got anything else to add on that?
I think it comes down to what the internal agreement was between all parties. I think if Company A subcontracts Company B and goes, it is your job to do all the due diligence, it's your job to get all the ecological surveys and things like that done before carrying out the work, and then they don't do it, I think there's an argument that Company A has discharged their duties, done everything that they should have done, and they would not be liable. If Company A instructs Company B and just neither of them have a conversation about whose responsibility it is and then it all goes wrong, there's an argument that both of them are liable. Yeah. I think it comes down to specific agreements between companies, which can be quite challenging to prove, but that's what it comes down to.
Yeah, I'd imagine that would be a bit of a legal minefield and probably a lawyer's holy grail almost.
Just on that.
Yes.
It emphasises 2 points that have already been made today, but I don't think can be said often enough, which is both examples given by both of my colleagues here on the panel indicate the importance of looking at the facts and the circumstances of each individual case. And you can't escape from that. And the second point is the one that Ian referred to you earlier around causation, because the Act or the bill as presented at present, very clear about looking at the person who causes it. So that goes to the essence of who has done this, who did it. I mean it is a literal who done it. And so that's the guiding light in relation to it, and then drilling down to the level of detail that Ian's outlined for you.
And I guess it's checking whether the instructions were clear, flowing from the main contractor down to further ones. Okay, next question was, so the threshold for liability for senior responsible officials of an organisation is consent or connivance. The committee has heard views that consent, connivance or neglect would be preferable. Do you have views on that? Maybe go to Claire first of all.
I think that it depends on what direction the bill is to go in, based on what has already been said and raised sort of quite pertinently there regarding who might commit this sort of act and how you want to hold them accountable. If you include neglect or any sort of negligence within the definition, you broaden it and you make it much more open. So acts which lack that intention would also be included. But I'm not certain if you already have a test of recklessness there, if that would add anything in particular. Because once you've identified who you're going after, or who would be held accountable rather, you would then go back to the crime itself, which is already either intentional or reckless, in terms of the standard of sort of...
Sorry, Claire, are you saying that adding negligence really wouldn't add anything to this at all, or?
Not my mind, no, but others might have a divergent view.
Okay, Murdo, can I come to you?
I think it would add something, as I mentioned earlier, the concept of willful blindness or negligence, or even negligence drifting towards carelessness, isn't it? As opposed to recklessness, it must be lower than reckless. And I think that's in the original Act, as Ian says, it makes it easier for the Crown to prove. But in such a serious offence as this, I think it would be arguably a step too far to include that carelessness in that. I don't know why it's not there in the new section, but I think it's right that it's not there.
Right, okay. Ian, did you share that view, or would that make your job easier if that was there?
I think proving a negative is always challenging. I think proving consent and connivance is challenging enough. I think proving neglect, again, without specifics of a case, I can envisage that being a slightly challenging hurdle to overcome.
That's lower than having to prove connivance or consent, though.
Yes.
For you to prove.
Yes, it's easing the others, but still, yeah.
Okay. Rachel, anything to add?
No, nothing.
Okay. Thanks, Convener.
Okay, perfect. I think, Kevin, you've got some questions now you'd like to ask.
Thank you very much, Convener, and good morning to the panel. The bill itself does not explicitly set out that undertaking licensed or consented activities cannot constitute ecocide or provide a defence along these lines. That's raised a number of concerns from different sectors, including farming, fishing and renewable representatives during the course of these hearings. Is the approach in the bill appropriate, and what are the implications for regulatory certainty? And maybe we can go to Claire first, please.
I think that I understand that if that certain sectors might be concerned if there's another sort of criminal environmental offence in discussion and in debate at the moment. My understanding is that this is very, very severe harm, very serious harm, and I think clarity on the definition of serious adverse effects would help them to understand when these sort of activities might be identified. The lack of a permit, I view as in sort of development from the 2014 offence, is a positive step because these are supposed to be very, very serious harms.
So I wonder if I can stop you there. Say something is found out at a later date to be a serious harm, but it has been permitted, it has been consented. Do you think that it should be an offence in terms of the proposed ecocide bill?
If it's currently permitted under the current state of scientific kind of evidence, as it were.
Yeah.
I think that goes back to the definition and what sort of we understand as serious adverse effects or severe environmental harm. If you're defining it, and I think when I mentioned earlier the Convention on the Council of Europe Convention, the EU directive, they outline what sort of harms they cover, and then they say it's a very serious form of that harm. I think greater clarity around that definition would be very helpful because it might allow for things that are permitted at the moment not to be caught by that, if you see what I mean.
Thank you. Ian, please.
I don't think I have sufficient knowledge of the wider regulatory regime and the permit schemes to really sort of meaningfully comment on that. All I can comment is a recent example of there was a case against ExxonMobil where the offence we prosecuted them under was an offence of breach of permit, and we considered that was the appropriate offence to go down because the penalties were suitable for a breach of permit, and that was the most apt offence to prosecute them under. So it may be that in a sort of breach of permit situation there is specific legislation we could go down. How it would interact with this bill, I don't think I can really meaningfully comment further, I don't think.
But if it has been permitted and is later found out to be a bit difficult, it has been permitted, so you would not be able to challenge anybody for a breach of permit in that regard.
Okay, so if it's within the terms of the permit,
Yeah.
then there's not a breach of permit, but also I think then you're struggling potentially for the intent to cause harm or recklessness element, because if you had a permit, why would you be fulfilling either of those requirements?
Can I just briefly come in? What I'm not understanding and is, I think the suggestion is the issuing of the permit may have been reckless because it wasn't properly considered. That's, I think, unless I've got that wrong, Kevin, is that what you're sort of questioning?
Well, that was where I was going to go to
Oh,
next.
well, I
but
apologise.
anyway,
I think we'd be looking at the mindset of the accused. And I think if they had had a lawful permit, whether rightfully or wrongfully granted, if they had a permit that they thought they were entitled to act under, I think we would struggle to argue that they were reckless or they intended to cause harm.
okay. Murdo, please.
Yeah, I think the situation you're referring to is covered in the 2014 Act, but as I said earlier, is missing from the present Act, and I don't know why that is. I'm not a politician. It wasn't my idea, but it is a curiosity. All that I would say, though, is if one drills down into the bill a little bit, in terms of the corporate responsibility, it is a defence to, if you have just talking about my valve scenario or a subcontractor making a mistake, it is a defence for the company that it took all reasonable precautions and exercised all due diligence to prevent ecocide, and maybe having that permit could avail them of that defence. But you're right. I think the underpinning your point is that there's no reason for this amendment, and it does make it tougher for companies.
Yeah, we'll maybe come back to some other curiosities in a minute. Rachel, please.
It was to make the offer to the committee that we could follow up in a little bit more detail. I think the example you've given is really useful. If members have got any other specific examples around that particular element and how that would give rise to concern, we're happy to take that away and we'll come back in writing at a later date.
I think that would be useful. Equally, there's no defence in the bill that would apparently prevent a regulator or consenting body from being held liable for ecocide, again in contrast to the Regulatory Reform Act as mentioned by Murdo, which of course sets out the defences on both the side of the regulator and operator for authorised acts. Should regulators be protected from liability for environmental harm when issuing consents under the relevant legislation? Are there instances where a regulator should be held liable? I have to say that certain aspects of this have caused quite a lot of consternation as our hearings have gone on, and have certainly led to food for thought for the likes of councillors who serve on planning committees. I wonder if we could start this time with Rachel, please.
I think it's an opposite question, but it's a question of policy rather than practice.
I thought you would say that.
But it really is. It's a question of whether Parliament would intend and consider it appropriate to place regulators in either of those positions, either to hold them liable or not to hold them liable. As it's currently framed, the bill indicates it's a person that commits an offence, so it could be very widely interpreted. But again, that would come back to parliamentary intent, and one of the factors we would look to is not only the kind of discussions that take place in committees such as this, but also in later stage debates and in explanatory notes around it. And it's something that would probably be worth clarifying.
Okay, Murdo, please.
I think there are other scenarios where regulators could be prosecuted. But I don't think this is one of them because, as Rachel hints at, the person must cause severe environmental harm and intend to do that, or is reckless about it. And I think it's difficult to imagine a situation where SEPA would be acting recklessly in this context, or obviously not intending to cause environmental harm. So I'm not sure that that itself is a test that would be met easily by the Crown. But I go back to my original point, which is I share your observation about the failure to mention that in the present bill as a sort of belt and braces exercise.
So it is a failure in your opinion as well?
Yeah, I think I'd be happier with it in there. But again, it's a matter of policy, really.
Okay. Ian, please. I'm sure
I've
you're
got
going to
nothing
tell me
helpful to
exactly
add
the
to
same
my
thing.
colleague's answer, I'm afraid.
Okay, thanks. Claire, please.
I think I was going to say more or less the same. I don't think I can add anything. But just in relation to the earlier point, I think what's been demonstrated very clearly is the idea of intentionality or recklessness. Means that if you had a permit, it would be much harder to prove. If that permit had been gained in a way which was through corrupt means or something, I think there might be, to be very specific about it, that might speak to intention. But beyond that, if a regulator issues a permit in good faith, and if the permit is granted and exercised in good faith, then I would think it would be very difficult to prove there was an intention there to cause environmental harm, or there was recklessness as to whether or not the harm was caused.
But would you agree with Murdo that it's a failure that aspect is not transferred from the 2014 Act into this Ecocide Bill?
I wouldn't necessarily characterise it, apologies, as a failure, because I think that the particular drafting of this bill reflects the fact that it's been inspired by the 2014 Act, but also by the international definitions. And international criminal law always focuses on the individual. So it's natural that this does focus on the individual in the same way. It focuses on individual criminal liability, essentially. And then you have elements of the 2014 Act. I think that a bit of clarity on what the intended purpose of it, taking into account whether or not public authorities might be responsible, whether or not the focus is on corporate criminal liability. I think what the crime is, what the definitions are in relation to the crime, and to whom it, or who ought to be held accountable, essentially, are the questions that need to be answered to be able to then identify who should be held responsible.
But it provides no comfort for consenters, I think it would be fair to say. I have one final question, Convener. And Murdo earlier on mentioned the fact that this Parliament is currently looking at the dog theft bill, and the stealing of dogs is already a criminal offence, as we all know. And, you know, it does make me wonder sometimes whether we get our legislative priorities right as a Parliament. There have been indications today from the panel that maybe one of the options here, rather than this new proposed bill, is to go back and look at the Regulatory Reform Act and maybe change aspects of that, including the possibility for increasing sentencing under that Act. Would that be fair to say, Ian?
I think that would potentially address the issues that I have identified, yes.
Thank you. Does anyone else wish to comment on that? No? Okay. Thank you, Convener.
Can I just say one thing?
Please.
Lest it be thought that I thought that the absence of a permitting provision is a failure. I think what I actually said was that I would have preferred it to be in there.
Okay. Thank you for that. Thank you, Convener.
Sorry, can I just push a wee bit on this, just so I understand it? So, say, for example, at sea, say you had aquaculture that was using a chemical which was approved by the Veterinary Medicines Directorate to be used to kill sea lice, for example, in salmon pens. So the company apply to use it. They use it as per the permit that's issued by SEPA for an on-use licence, for an on-use use for the chemical that's achieved by the Veterinary Medicines Directorate. But it kills off all the starfish and all the prawns and all the lobsters and all the crabs in the area because they're affected by the chemical. Who then becomes liable? Because you're sort of saying that no one's liable because if it's all on permit, it's all hunky-dory. But everyone knows that that's the effect of that chemical. I'm trying to give you a real-time example in my mind which raises questions I mean, to me, that would be, if it kills off a substantial number, it could be ecocide in the locality where it's involved. Does anyone want to pass a comment on that, or would you care to follow it up in correspondence, Ian or Rachel or Murdo? Do you want to pass a comment on that?
Well, I just go back to what's been said earlier. There has to be an intention or a recklessness as to whether environmental harm is caused. So you can almost sort of park the issue of permitting for a second and just I think that would be our first port of call. Who is the ultimate duty holder here to the environment?
Well, I'm trying to find out. I'm not sure I understand.
It depends on the particular facts and circumstances, I suppose, as Ian said, in each case. And it's very, very complex, this field. And I think the point you make about when the knowledge is there that this is causing a problem is important too. And then pinning that on someone. And of course, science changes all the time. So, but I'm sure we'll all give it a little bit more thought.
It does, but I'm trying to where the events are known.
Yes.
If it is continued to be done, it would be reckless. We could end ourselves up like we are in Australia, where they introduced cane toads, which they thought was a great idea at the time, and now considered one of the biggest pests because they destroy every bit of natural wildlife in Australia, and everyone's encouraged to destroy them at every opportunity. So I'm worried that this doesn't address some of the things that are concerning. Murdo, do you want? Sorry, I thought you were taking a breath.
No.
No,
it's an interesting point, but these are, I suppose, matters of policy for this committee and for the Parliament to determine.
Okay, I'm going to move to Sarah then with her questions.
Thanks very much, Convener. The issue of penalties has been mentioned already, but I'd like to dive into that a bit more and get your views about the proportionality of penalties. The bill references up to 20 years imprisonment or an unlimited fine for an individual or an unlimited fine for an organisation. And we wanted to note that the committee's heard views that existing maximum penalties available under the RRA don't allow for alignment with developments in EU law under the Environmental Crime Directive. So interested to get your views about the proportionality of the penalties that are included in the bill. I don't know who wants to come in first. Ian, do you want to come in first? You're looking at me. And
yeah, I think one thing to be, it's perhaps trite, but it's worth stating that this sort of headline of 20 years, that only applies to individuals. Where we are prosecuting a company, the maximum penalty is a fine only, and it's an unlimited fine, and that already exists in Section 40 of the Regulatory Reform Act and numerous other environmental offences. So for companies, the maximum penalty is on par with numerous other pieces of legislation. I think this discrepancy between 5 years and 20 years only applies to individuals. And I think I would anticipate, and I think my colleagues would probably agree, that the scenario that we'd find ourselves in where an individual is finding themselves facing a prison sentence in general, let alone one over 5 years, would be a rarity. But that is, I think we have to accept, that is the discrepancy between this bill and the existing legislation, most of which the maximum penalty for an individual is 5 years imprisonment.
do you think there's an issue about a lack of alignment with EU legislation on that issue?
I think that would be more of a policy issue than a practitioner's view. I don't think I could really share a view on that, I'm afraid.
Okay. Murdo, did you want to come in?
I think, as from recollection, the EU directive suggests starting at 10 years. If there's a fatality and 8 years otherwise, these are maximum penalties, the 20 years. And whilst Ian says individuals, it's only geared for them. It is geared, I think, in terms of Section 3 for the very senior management, and as like a warning shot to them, this is what you could get. It's not uncommon to see directors charged in health and safety matters. There's a maximum penalty there of 2 years, which is significantly less. That's arguably inadequate. But the only other thing I would say is that we have a sentencing council that is currently looking at environmental and wildlife crime, and they tend to set the range that sentencers have in which to deploy this. And, for example, in road traffic matters, one thinks of death by careless driving, where there's a maximum sentence of 5 years. The maximum range that the Sentencing Council has left open to sentencers is between essentially community payback and 2 years. So that will temper, I think, the effect of this 20-year maximum. So on the one hand, you've got that backstop, but on the other hand, if you're passing this legislation, you might want to have that headline figure to act as a deterrent.
Okay, that's very helpful. The other witnesses, have you got any comments on that?
I've got nothing more to add to what Ian has said.
Okay. Claire, did you want to come in on this point?
Yes, very briefly. No, I don't think it's out of step with international law or European law on the same point. The question is whether or not you would want to add in the restrictions on it. So there's in the directive, for example, the EU directive, there's a mention of the gravity of the offence. So it can temper the penalty according to how serious the offence is. So then another, and as has been already mentioned, where someone dies as a consequence of the harm, then the penalty indicated is more severe, or the maximum should be higher. So there's more detail essentially in EU law and the Council of Europe Convention as well. So it's not out of step, but it maybe lacks the detail of the other instruments.
Okay, that's very helpful. Sorry?
Murdo made. Murdo referred to the Scottish Sentencing Council currently looking into sentencing guidelines in relation to environmental offences. I'd simply flag to the committee that that already exists in England. So publicly available, there are the English Sentencing Council sentencing guidelines for environmental offences. We, as a matter of practice, will present those to the court upon conviction in Scotland. Not binding on a Scottish court, but I think there's case law that establishes that they can be used as a tool to assist the sentencing sheriff or judge. And just as a point of reference, in those guidelines, the recommendation, the sentencing range for an individual who is at the highest level of culpability and the highest level of harm caused, the recommended sentencing range is 1 to 3 years. So that's kind of what the English Sentencing Council are. That was their view when drafting those guidelines. So I simply draw that to the committee's attention.
Okay, thank you. That's helpful. The next question I was going to ask about was issues about remediation being provided. And that would be by an operator, not just a compensation payment, and also looking at the issue of the confiscation of the proceeds of crime. Do you think the bill goes far enough in these areas, or do you think it should go further? Or an alternative suggested was potentially you could do those penalties under existing laws, such as the proceeds of crime legislation. What do you think the best options are in terms of the bill or other options? Murdo, do you want to come in?
I think there would be no impediment to a prosecution, an attempt to recover under the proceeds of crime legislation. The remediation is an interesting aspect because it was actually in the 2014 Act, but it isn't in the in this bill. There's a compensation package, and the accused would have to pay for the cost of remediating, but of course not actually remediate themselves. And that was a curiosity, I thought, in this bill.
Okay. Anyone else want to come in on this issue?
I think it's a question, moving away from the question of remediation, which is a question of policy as to what the bill's intent is and what measures should be available. Just for the benefit of members of the committee, convener, it's worth mentioning, although proceeds of crime is not mentioned in the bill, it is a separate provision that runs in tandem to any criminal proceedings in Scotland, and so the provisions of the Proceeds of Crime Act would be available for criminal confiscation in the event of conviction.
Yeah.
And we would anticipate using them in appropriate cases where we could show that there is a benefit from criminal conduct.
So it could be there in parallel anyway. Yeah. Okay.
We have historically used it in environmental cases. There are previous cases of ours that we have used proceeds of crime proceedings after the conviction. Okay,
thank you. Claire, do you want to come in on this?
Yes, just very briefly, that in the EU directive there are penalties which go beyond those of a financial nature or even of imprisonment nature. Things like placing a company under judicial supervision or what I think is particularly innovative, closing the establishment that's used for committing the offence. So there's a list really there in the directive which allows for punishments or methods to be undertaken to essentially deal with the problem as it stands and prevent it from happening in the future, which goes slightly beyond traditional punishments of fines and imprisonment. Within a criminal bill, I don't think these are particularly typical. I'm happy to be corrected on that point by colleagues, but it might be something worth thinking about slightly more broadly, where, given the examples we've heard today, it might be more constructive to think about how to undo the damage and how to prevent it from happening in the future, by making it clear to those who might be responsible that it will have a really heavy impact on their business regardless of their turnover. So if were they to undertake these things, were they to cause this harm, there would then be damage, consequences, perhaps not damage, consequences to their operations, which might not necessarily be recoverable for them beyond financial consequences, which seem much more recoverable in practice.
So sorry, just to clarify, do you think that should be in this bill or existing legislation? You're saying it's additional opportunities to hold companies to account?
Yes, I think that you could look at this and say, is there something perhaps more appropriate than a prison sentence or a fine, as it were? Is there something that could be done there? Because I'm not certain. I know there are, as has been mentioned, community payback orders and things like that, but would that have any impact if the boats were still able to go out, or given the earlier example, or the factories were still able to run, particularly if you're targeting one individual? So I think that a more, and perhaps a broader scope of what it is that you could do to remediate the damage might be productive.
Okay, do other witnesses have thoughts on those ideas?
Timescale of a prosecution concluding, the time it takes to investigate, the time it takes to have a case concluded. If you're waiting on the outcome of the criminal case before then being able to start clear up of whatever the incident is, practically speaking, that could prove to be a problem, an issue. So we've encountered that in offences we prosecute under the Nature Conservation Scotland Act, which is damage to SSSIs. We've had some cases which we've taken all the way to trial, and at the end a restoration order was imposed. I think Nature Scot found that the timescale proved problematic, and so actually now in a number of cases we've received, a collaborative approach was taken with Nature Scot where it was decided, do you know what, it's not in the public interest to raise a prosecution, let's just go straight in with a restoration order, because the priority is addressing the environmental harm now. So I think timescales is something to bear in mind if that was an outcome of a prosecution.
Just before we leave that, sorry, if you finished on that particular area, I'm just intrigued on that point, is that it seems to appear to let somebody off the hook, as it were, just so they can repair something. Is there anything in the legislation that would allow the statutory bodies, or should there be something in this legislation to allow the statutory bodies to start off with the repairs to the environment that's been caused by this? Because, you know, delaying it for 2, 3, 4, 5 years is just basically making the problem more difficult to solve. So would this bill be enhanced by giving powers within this to allow public bodies to leap in and start repairing things if damage is identified? Murdo, you're looking concerned.
Only because of my lack of knowledge in this particular area. And certainly in health and safety, which is the bulk of my practice, there is a sort of separate regime of improvement notices for the same facts, the same sort of incident that's happened. I'm not entirely sure if there is the same in environmental crime or not. So
I think the answer which one could give is that if a track was built through a peatland, which was a SSSI and an SPA, for example, if you left it for 5 years, the drainage that would happen as a result of that track being put in would affect not only the small area of the track, but would probably quadruple out either side of it. And so therefore I'm just wondering if that should be covered within here as well. Sorry, Sarah.
That's okay.
I mean, certainly the approach for the damage to triple SII equivalent, in that situation, one option is that NatureScot can impose a restoration order. If they impose a restoration order, that prevents us from prosecuting the company or the accused for the original offence. However, it remains open that there is a separate offence of breaching a restoration order, so that if they then fail to do that work, there is an option of us prosecuting them for the breach of the restoration order, but not for the original offence. So there is a very careful, in those few cases I've given an example of, a very careful discussion was had with stakeholders to decide what was best in the overall public interest. But that's the approach in those cases.
Sounds like there's a backdoor escape route here. Sarah, sorry.
Okay, well, it actually does lead on to my next question, which is about Section 9 of the bill, which extends enforcement powers in relation to ecocide. Is it sufficient to ensure that the relevant authorities have got the power to investigate a potential offence? And is there a gap in powers between any regulatory or enforcement bodies to investigate potential severe damage to the environment within their remit? I can see reflective thoughts there in terms of reading your expressions.
I do. I think it's something that I think would be best for us to follow up with you after today's meeting.
Okay. Anyone else have a thought just now? No, it just follows on quite nicely that discussion about if an organisation thinks that there's been a potential offence, that time issue that came up in the last question by the convener, how do you actually get action to take place? And that's one of the options. Okay, if nobody's got a particular answer but you want to get back with us with further thoughts, that'd be very helpful. Thank you. Back to you, convener.
Thank you, Sarah. And just looking around the committee to see if there's anyone else who wants to ask any questions, then I will go to Monica and let you have a few questions, Monica.
Okay, thank you, convener, and good morning to our panel. I was interested in the analysis that there is nothing lacking in existing legislation in terms of being able to prosecute for an ecocide level crime. But we have heard from other witnesses who take a view that currently there could be goods and policy divergence between what we're seeing emerging in the European Union with the Environmental Crime Directive and how that's been adopted by member states and the situation in Scotland. So just to get some clarity on that, is it the view of witnesses today that Scotland is keeping pace with the European Union, or is there anything that could or should be done just to make sure that everything is in alignment?
I don't think it's really our place to comment on whether we're keeping pace with the European Union or any other international body. Again, at the risk of repeating myself from earlier, that's a determination of policy as to whether our policy in Scotland is coherent across a European context, and not a question really for practitioners.
Okay, well, maybe I misunderstood what you were saying earlier on, but so the government's position is that in order to align with the policy and legal direction, then we need to look at how we give effect to ecocide law. One option the Scottish Government looked at was amending the RRA, so that proposal hasn't come forward. Okay, another question, because other stakeholders, witnesses and people responding to the call for views and any other consultation is that there are gaps in environmental governance in Scotland, both in terms of how people access justice and just how things operate. Is that something that you recognise or have a view on?
Could you elaborate on what those gaps are?
In terms of environmental governance, I think the committee's heard evidence about Scotland not complying with the Aarhus Convention. We don't have an environmental court. Communities find it very expensive and difficult to access. Things like judicial review. If you don't recognise that, that's okay. I can move on to other witnesses.
These are matters more for the civil courts, perhaps more than the criminal component.
Okay. So there's no improvements that you would want to bring to attention. Perhaps Claire Francis, did you have anything to add on that?
I'll be completely transparent and say that I am not an environmental lawyer, so I don't have anything that I can usefully add in that respect. But from your earlier point in respect of keeping pace with the EU and other European instruments, what I find quite interesting is that with the expert panel definition of ecocide, that's been taken on by the Belgian government, and that reflects the sort of the original definition that they have, which will then be discussed later on in December at the Assembly of States Parties. But the Council of Europe Convention, which is open for signature in December, and the EU directive both have chosen to elaborate examples of what environmental crime might look like, and then, as I said earlier, be much more specific about those points or about those crimes, and then what might be quantified as a particularly serious crime, and therefore might be tantamount to ecocide. Beyond that, are there therefore gaps in Scotland? I think in the criminal law there's a vast array of regulatory offences, and there's a sort of overlapping regime which has been spoken of favourably in the context of the EU directive, that both are required. You require a regulatory system and a criminal system to deal with the problem of sort of environmental degradation. What's missing from this bill, which might speak to the problems that have been encountered, is that regulatory element. I'm not sure that there are any existing provisions which are fully either criminal or civil, or regulatory perhaps, best way of phrasing it, whereas this is purely criminal. I wonder if that might be the reason for perceived shortcomings, even if the shortcomings don't bear out in practice, because as the committee have heard today, practice can often differ quite widely from what exists. How the practice and the decisions that are taken in practice encompass a wider range of considerations than what's written in the law.
Thank you, that's helpful. Just a question on enforcement. Another issue that's been raised is whether SEPA currently has enough resources and enough expertise to deal with complaints in case it comes to them just now, because a lot of their work is intelligence-led. If this bill was passed, does it raise any issues about enforcement for SEPA or any other body?
All I can speak to is a very positive working relationship with SEPA. As I say, I have meetings with them every 6 weeks. We have clear ongoing discussions about ongoing investigations and live cases, so it's a very positive relationship. I couldn't possibly begin to comment on their resourcing implications or abilities behind the scenes there.
Okay, thank you. And no more comments on that. And just a final point, Convener, was just the notion of a deterrent has come up a couple of times, and the witnesses have recognised that when policymakers talk about ecocide, it is talking about the most severe and thinking about events that might happen on a very rare basis. I think in the bill we talk about a sort of a period of between 10 and 20 years would be the likelihood. Is there anything you'd want to say about the sufficiency of the current deterrent? And another issue that's been raised is just how we better inform and educate the public, because knowledge of science and issues about environmental harm do change all the time. So is there anything that could be done to raise awareness of the current legal framework that we have in Scotland? And is there anything we could do to create more of a deterrent effect? Murdo.
Just go back to what I said an hour ago about the setting aside the duplication points and any perceived inadequacies in the bill. This is in many ways a symbolic bill. I think the phrase I used was it does what it says on the tin. It's at the top of the sort of regulatory or environmental pyramid of prosecuting that we have. I don't think there have been any court prosecutions in terms of the 2014 Act. I would envisage that there would be very few if any, under this Act. But of course, we've got a Treason Act. We've never convicted anyone for treason in this country, going back to the 1300s or so forth. We've got the Bribery Act. Everyone knows what that is. So in terms of having a headline act, corporate manslaughter and corporate homicide act, another good example of raising public and boardroom awareness. And the point I was making earlier was that the existing regime is tucked away in the 2014 Act rather obscurely. So if the policymakers wanted to use this as an opportunity to encourage the deterrence of it, then it is a laudable aim. The question for you is whether that's what this Parliament is about or not.
Thank you. Thank you, Convener.
Thank you. I was just, I'm going to have to do some research on that, Maddo, on when the last prosecution under the Treason Act was. I'm sure you're right, but it's an interesting act. Anyway, on that note, thank you very much for all the evidence that you've given this morning. It's been very helpful and will help us with our stage one consideration. I'm now going to suspend the meeting till, at the earliest, 11:10 to allow members to take part in the Armistice Day service that's downstairs. But thank you again, and I now suspend the meeting.